Good morning. Happy Sunday. Happy Mother's Day to all you mothers out there. To all you mother lovers. I'm a mother lover. He's a mother lover. I don't remember the song, but it's hilarious from Saturday Night Live. Prep work. Anyway, I'm wearing flip-flops. I apologize in advance if that's going to bug you. I'll get to the meaty stuff first. First, the juicy gossip is that Leon Valley released back to the, I don't know what you want to call them, witnesses, arrested parties. They released back all the cell phones and whatnot. So that's great. You know, you got Earl posting up that there's evidence of collusion. Conspiracy to commit what crime, Earl? What crime? Name the crime, Earl. Anyway, he sent it to his attorney. You know, before he can release it to you guys, he has to clear it with his attorney. Well, here's the first thing, you fucking retard. And I say that to Earl with love and respect. There's this thing called discovery in civil actions. Well, it exists in criminal actions too, but in civil actions, it's really easy to get discovery. What your attorney should do as soon as he receives it, since it is germane to the subject matter of the allegations that you are making against Leon Valley, is he should turn that over to opposing counsel. I think Earl's part of the Leon Valley lawsuit. If he's not, then, well, time's ticking. I don't know what the statute of limitations is on personal injury in Texas, but whatever that is, that's the statute of limitations. So if he hasn't already filed, he should. And if he has filed, well, then discovery is available. And if he hasn't filed, then discovery will be available, and Leon Valley will be simply able to ask for those videos. Same for everybody else who got their phone or camera back. If Leon Valley was not able to secure a warrant, if they weren't able to secure a warrant to get into the phone or camera, if they weren't able to access the data, now all they have to do is send to your attorney a request for production for all of those videos, and you should comply with it. There are sanctions that can come about if you don't comply with it, up to and including issue sanctions, which means that you could just simply lose the case if you refuse to provide the evidence that they're requesting. Anyway, he's not going to show it to us until his attorney's had a chance to review it, because it's going to just change everything if, you know, his attorney decides to use it in the case. He just won't be able to make it public, guys, because, I mean, obviously, if any video becomes public, it can't be used in court. Except we literally saw in Epstein that they used videos off of YouTube. Not Epstein. God, I always say Epstein. Winehouse. In Winehouse, Jeffrey Winehouse, they used videos off of YouTube to, against him in court. So, yeah. So Earl's just being stupid again. Now, in different news, I had a comment. It was an interesting comment, and so I'm going to share it with you. I was told that I was wrong. I was using quarantine wrong. I was meaning isolation by quarantine, and isolation is different than quarantine. And okay, I mean, I'm not using them in the medical sense. I'm using quarantine in the legal sense, and I provided the commenter with the link to the case that I read, because believe it or not, I mean, you might find this odd, but the reason why I am seldom wrong is because I actually do a modicum of research before I talk about a subject. I may not go into extreme details, but I will do a modicum of research. Now, the case that I presented to him was a 1948 case from the California Court of Appeals. So it's the middle level of California. It's not from the California Supreme Court. And in this particular case, two women, suspected prostitutes, were quarantined in a jail. And they were being held, I think it was by the Alameda County Sheriff in a Richmond jail. They were being held there because there just wasn't a better place for them. But they said that they didn't have syphilis and that they should be released. And so they filed a writ of habeas corpus, because in California, and I'm sure in most states, but in California, the way to fight being quarantined or put in isolation is to file a writ of habeas corpus. And that will get you in front of a court. And in California anyway, whether it's quarantine or isolation, doesn't fucking matter. The state has the burden at that point of showing that you have the disease. And the level of their showing is the same as it would be in a criminal case in order to detain you for trial. And that would be a showing of probable cause in the criminal case, but they call it reasonable something or the other in the civil. And I don't remember the exact name of it, but they talk about it in the case. And if I remember to, I'll link the case in the description. So if in this case the women were still, and the court talks about this, if they were still infectious, or if the state couldn't prove to the level of probable cause that they had syphilis, then they had to be released. And the court held in this particular case, because it takes 8 days, apparently, at least for the ability to test back in the 40s, it takes 8 days for the lady parts, in the absence of medications, to show, for them to be able to actually test for syphilis down there, because they could use antibiotics or topical disinfectants, apparently. They have to quarantine them for 8 days to show whether or not these ladies indeed had the syphilis. And the state could show, they proved with the same level of probable cause, that these ladies were prostitutes and that they were engaged in prostitution, and that was enough probable cause that these ladies had syphilis. So it's not a very high standard of proof, but the state has to show to a standard of proof that you have some sort of an infectious disease. Law is not medicine. I mean, if the state can prove that you actually have the disease by a medical report, then that's easy peasy lemon squeezy. They could prove that beyond a reasonable doubt. But the standard showing, the standard of proof consistent with due process, which is what I was talking about, there is a due process requirement, is that they show that you have the disease. Probable cause, you have the disease. Now, the reason why I talked about endo, ex parte endo, is because in endo, the petitioner, the one who filed her writ of habeas corpus to be released from the Japanese internment camps, the government could not prove that she was anything but a loyal citizen. And so they had to let her go. If the government can't prove that you have been exposed to and are likely carrying, and there's probable cause that you're infected with the coronavirus, and then they would have to let you go. Now, the problem with the mass stay-at-home order is that there is no way the government can prove. It's indiscriminate. They can't make that requisite showing of probable cause for every person. People who haven't left their recluses, who haven't left their home in forever, who have never left their home in the last 40 years, who get nothing but mail order MREs, military rations, whatever they call them. Those people are as subject to the stay-at-home order as everybody else. And if you make a law this broad, then it is unconstitutional on its face, in my opinion. And I don't have case law to prove it. That's why I had to use 2 cases to make the argument. It is unconstitutional because it is affecting people who the state knows or should know there is no probable cause for their detention, for their quarantine or isolation, if you're really still stuck up on that. And apparently this commenter was still really stuck up on that, because despite me having provided with him a case showing that it is consistent with due process that the government has to show to a level that amounts to probable cause that someone is infected and contagious. That's the language out of the statute, or I'm sorry, that's the language out of the case. Went on to argue that apparently I'm still wrong and that I am still using the words incorrectly, and that I fail because I am citing California law and I am referencing a case that is not a California Supreme Court case. And these two things are fairly common. So let me explain both. Number one, I don't care about your picky-unish details. I don't care about the medical difference between isolation and quarantine. I care about what the stay-at-home order is, which is in effect a quarantine order for everybody. In order for there to be a quarantine order, the state has to prove to a certain level, probable cause, or the civil equivalent of it, that you are in fact carrying the virus. It's a very low level of proof, but it is a level of proof. And proof comes in many flavors. Evidence is something that tends to make a fact more likely. It doesn't have to be 100%. It doesn't have to be the smoking gun. It doesn't have to be the high definition video expressly showing you pulling the trigger and killing the person. Circumstantial evidence, the preponderance of the evidence, beyond a reasonable doubt. I mean, these are standards of proof, and you compile all your evidence until you hit those standards, or you compile evidence until you make it clear that they can hit those standards, whichever side you're on. Second thing is Supreme Court cases. Not everything goes to the Supreme Court. The only things that go to the Supreme Court are things that really kind of need to go to the Supreme Court. There is a difference of opinion in lower courts, or new case law has come out that is that's put a question mark on established Court of Appeals stare decisis. And so it has to go to the Supreme Court for resolution. That's the only stuff that goes to the Supreme Courts. There's this, I mean, if you open up a California practice guide for whatever, you pick it, or a federal practice guide for whatever, you'll find lots of cases that aren't Supreme Court cases. In fact, rarely do they cite Supreme Court cases, because there are usually lower court cases that are more on point. Most of the basic things have been decided by low-level cases, by appellate court cases, and not by Supreme Courts. It's only when there is some sort of an issue, a split among the appeals courts, or some new case that was decided by a Supreme Court, the Supreme Court, that sheds some doubt onto past Court of Appeals cases. So, I mean, that's just what lawyers deal with. We deal with Court of Appeals cases most of the time. Very rarely do I cite a Supreme Court case. Anyway, that's about it. Thanks for watching. Have a great morning.